Welcome to Judicial Watch. I'm Tom Fitton. I'm president of Judicial Watch, and we're a conservative, nonpartisan educational foundation dedicated to transparency, integrity, and accountability in government, politics, and the law. And through our educational activities, we advocate high standards of ethics and morality in our nation's public life and seek to ensure that public officials don't abuse the powers entrusted to them by the American people. And we strongly believe in the rule of law, and to that end, a government that adheres to the limits imposed upon it by the Constitution. Our panel today is entitled Hillary Clinton's Email Scandal, and it's designed to educate you about the facts and legal issues behind the revelations that Hillary Clinton immediately upon becoming Secretary of State created a secret email account or accounts to conduct all of her government business. And no one knew about this, supposedly, at least publicly, until just earlier this month. You know, from Judicial Watch's perspective, we've seen this story before. Back during the Clinton administration, it came to our attention from a White House whistleblower that there were 1.8 million emails that were not being records managed properly in the White House. And as a result, those records were not being searched in response to subpoenas and document requests. Our requests for information at the White House at that time were focused on as part of our litigation over the mishandling of FBI files, as we alleged by Hillary Clinton and the White House. And it turned out Office of Independent Counsel investigations were being impacted by this failure to look at those records. And it was a big mess, because the whistleblowers told us that when they raised this with White House officials, this gap, that they were told if they told anyone about it, they'd go to jail and lose their jobs. And so we had a months-long hearing before a federal court judge, Royce Lamberth, that saw the testimony of White House officials, including John Podesta, who was, I think, then Chief of Staff, Charles Ruff, who is now deceased, but then was White House counsel, and Cheryl Mills, who was a deputy counsel in the White House, and later became Chief of Staff to Mrs. Clinton in the State Department. And the court, although the court unfortunately didn't find any obstruction of justice as we thought there was, but Judge Lamberth said this about Ms. Mills' participation in the matter. He called it loathsome, and he further stated that Mills was responsible for the most critical error made in the entire fiasco. Mills' actions were totally inadequate to address the problem. So in the sense that Mills was responsible for the failure to disclose to the investigators and the American people about these emails, she had been highlighted for a special calling out by a federal court judge back during the Clinton years. Back in 1990, I guess the whole scandal took place in the late 90s, and the court's ruling was a bit more recent. But I can tell you, she was under oath over an email scandal back during the Clinton administration. I don't think that's been well understood. So obviously during the current administration, Judicial Watch has been very active in the area of the Freedom of Information Act. And we've filed over 160 requests, for instance, with the State Department under the Freedom of Information Act. And we've sued approximately 20 times under the Freedom of Information Act on issues ranging from Mrs. Clinton's ability to raise money through her husband and her husband's conflicts of interest potentially. At the State Department, we obtained and reported on exclusively, at first with the Washington Examiner, about all the money that she was raising and all the conflicts of interest checks that really weren't being done. She was able to get, her husband was, to her benefit and to the benefit of the foundation, I think $48 million in money while she was at the State Department from virtually everyone who wanted to get influence with this administration, or perhaps influence with the successor president to President Obama. And that litigation, by the way, is ongoing. And also we were involved in much litigation over the Benghazi scandal. Mrs. Clinton, of course, notoriously had put out there, along with Mr. Obama and Susan Rice, her employee, the fake talking points that the Benghazi attack was in response to a spontaneous demonstration caused by people upset by an internet video no one had seen. And despite all the evidence to the contrary, both publicly, they continued to put this line out. And it was designed, in my view, to help two presidential campaigns, the president's re-election campaign at the time and her nascent presidential campaign. And so our document request and subsequent Freedom of Information Act lawsuits did much to uncover facts about Benghazi, about the security mess there, about the intelligence that the administration and Mrs. Clinton and the State Department actually was getting, as opposed to the intelligence they pretended they were getting. And the intelligence they were getting shows that it was an attack, and they knew it was an attack from the get-go. And yet, in the middle of this attack, Mrs. Clinton put out a statement seeming to blame it on a video. And that information just came out over the last few weeks as a result of one of our Freedom of Information Act lawsuits. But that lawsuit was the follow-on to another lawsuit we had filed that really blew the Benghazi scandal wide open last year. And it was in that lawsuit that we were able to uncover a White House document showing those talking points that Susan Rice used to get out to the American people on the Sunday after the attack on all 5 of the Sunday morning talk shows. That again, it was a terrorist attack. It wasn't a terrorist attack, that it was a spontaneous demonstration resulting from that internet video. The administration has said, well, we're basing these on what the intelligence folks were telling us. And we have been investigating this and getting document after document from the administration. And we'd gotten talking points, but they were for Congress. They were false, but they were for Congress. And then finally, we get the documents as a result of our FOIA lawsuit that show that it was the White House that sent out the talking points to all the folks in the White House who were part of the political messaging team of the administration. And the planning was out of the White House for what Susan Rice would be saying on Benghazi that Sunday. So the White House had not only been lying generally about what was behind the attack, and they were caught in that lie and they had to walk it back, but they had been lying about their involvement about that misleading information put out in the midst of the presidential campaign. And that caused Speaker Boehner, that document had been turned over to Judicial Watch under our FOIA lawsuit, despite 5 investigative committees of the Congress not being able to get it. That caused Speaker Boehner, who had resisted the appointment of a select committee, to say, thanks to Judicial Watch, we're going to appoint a select committee. And the history of that select committee resulted in some ways in the disclosure of this material. But let me just say this, when we got those materials out of the State Department about those White House talking points, that Ben Rhodes email, that smoking gun, we were curious that no Hillary Clinton emails were produced. Now, of course, we're thinking, well, maybe we did something wrong. Maybe we didn't ask the right way, or maybe we allowed the State Department to search only one part of the agency and not Mrs. Clinton's office. So just to be safe, we filed another FOIA request asking for records from her office about this issue of the White House talking points. Typical for the administration, they told us they didn't respond as they're required to under law, so we had to file again. And they gave us some of the documents we'd gotten last time. And so we asked, what did you get? Where did you search? And when we asked what did they search, that's when we got the Justice Department in December essentially telling us there's some other things we may need to look at. And then in February, they told the court in a filing in that case, we'll give Judicial Watch everything we could after we searched, but there may be other things we need to look at. They didn't tell Judicial Watch or the court. Something they knew at the time was that they hadn't searched Hillary Clinton's email accounts were the email accounts of any other employee that were not that were on this secret email system. And by the way, when they told us and gave us a list of the records they were withholding in a Vaughn index, it's called, just a few days before they had gotten those emails from Mrs. Clinton, those 55,000 records. And then they give us this document, and they never told us that they hadn't even looked at these records. And I don't think it's any coincidence that a few weeks after, they kind of hem and haw to the court that there may have to be other records they need to search, that these records became disclosed via the New York Times in what I believe to be a friendly leak to the New York Times. They didn't tell any of the courts this, and I can tell you, given the number of lawsuits we've had, we have closed lawsuits based on representations the State Department made that Hillary Clinton's records have been searched. So not only had they gamed Judicial Watch, but they had gamed federal courts who they had also assured they had conducted a diligent search. Now, to be clear, Mrs. Clinton began this cover-up the day she came into office, and this 7-year cover-up ended this month. But when you're the head of an agency and you come in and you create email solely in a secret way, solely to conduct government business, we just have to assume you're up to no good. And I'll defer to the lawyers here as to the nature of the violations of law here. But think of the disruption to Judicial Watch's 20 or so cases in federal court. We've gone initially to one court asking for another hearing, another one to reopen it, one of the cases that had been shut down. And we're just one litigant. Think of all the litigation the State Department is engaged in every year. Think of all the FOIA requests the administration gets every year, all of which have been distorted and obstructed. Think of the congressional requests for information and subpoenas that the State Department had gotten over the years that had been related to Mrs. Clinton's emails and would have required a search of those records. In my view, there's significant criminal liability for Mrs. Clinton if there were an honest Justice Department. Congress is unable, it's shown itself unable, unwilling to enforce its powers to obtain these records and overcome repeated Obama administration obstruction, as most recently evidenced by this State Department Hillary Clinton scandal. And now we see the President himself is taking steps to protect his emails from public disclosure or questions about them from being asked. His Office of Administration, which for 30 years prior to court action by both the Bush and Obama administrations, had operated as if it were under the Freedom of Information Act. And then George Bush decided he didn't like the questions he was getting about emails. So he asked the court to say, hey, we're not covered anymore. And the Obama administration continued that argument and successfully was successful, at least at the appellate court, in getting that done. So the Office of Administration still had these regulations out there for 6 years after that ruling saying they were subject to FOIA. Why after a few days later, why after only a few days after, why after just a few days following President Obama's disclosure that he communicated with Mrs. Clinton on the secret email account? And that, frankly, people first understood that he used emails too. Did the Office of Administration General Counsel issue a set of regulations tearing up all the FOIA regulations that may or may not apply to the Office of Administration? Now, why is the Office of Administration important? Because that would be the agency under the Freedom of Information Act that you would be asking questions about in terms of how White House emails were being maintained and organized. So they cut off any possibility of any questions, or at least under FOIA, as far as they were concerned, of questions about the way Mr. Obama kept his emails. And by the way, we never received Obama emails in any of the several thousand Freedom of Information Act response that we have obtained from this administration. So there's some questions there. So this is a scandal not just about Mrs. Clinton. It's a scandal about the State Department. It's a scandal about the Justice Department. It's a scandal about the Obama White House. It's a scandal about the failures of Congress to conduct effective oversight. and it's a scandal about the lack of interest in the media and in the institutions, the government institutions that we're charged with enforcing the law and making sure that there is at least enough of an element of accountability that a Secretary of State wouldn't dare do what Mrs. Clinton had done. So with that background, I think I'm going to turn it over to our guests. We're very lucky because we've got a former FOIA official who been in the Justice Department for many years, is arguably as influential in setting up the FOIA systems as much as anyone in living today. We have a former prosecutor and independent counsel, someone who knows what it's like to ferret through prosecution and overcome obstructions. And we have our Judicial Watch counsel here, Paul Orfanedes, who is, I don't know if he will take this as a compliment, but probably the #1 FOIA litigator in the country. First joining us, and I'm going to go by order of appearance, I'm going to do the backgrounds of all of our guests, and then we'll get their presentations and then allow time for interaction with our audience, is Dan Metcalfe, who's in the center here. Dan joined the faculty of AU's Washington College of Law in 2007 as a faculty fellow in law and government upon retiring from a career in government service that began at the Department of Justice more than 43 years ago. Dan now heads for the law school its Collaboration on Government Secrecy, a nonpartisan educational project devoted to openness in government, freedom of information, government transparency, and the study of government secrecy in the United States and internationally. But for more than 25 years, Metcalfe served as founding director of the Justice Department's Office of Information and Privacy, guiding all federal agencies on the interpretation and government-wide administration of the Freedom of Information Act. And he supervised the defense of more than 500 FOIA and Privacy Act lawsuits in district and appellate courts. I don't want to know how many times you were on the other side and on our cases, Dan. He also served as an advisor for numerous other government agencies, including DHS, the Office of Director of National Intelligence, and the National Security Council. He testified on behalf of his group, the Collaboration on Government Secrecy, before the House Committee on Oversight and Government Reform and the Senate Judiciary Committee. I had the honor of testifying next to you, I recall, on FOIA matters. Yes. As an expert on government FOIA administration and the proper implementation of new FOIA policies. So we're very lucky to have Dan share his expertise with us. Also joining us all the way there at the end is Joe diGenova, who is a founding partner of the Washington, D.C. law firm of diGenova and Tensing, which represents individuals, corporations, and other entities before the federal courts, Congress, U.S. cabinet departments, and agencies on criminal, civil, administrative, investigative matters. And he and his wife, Victoria, have done great work and yeoman's work, often pro bono, on behalf of government whistleblowers. So he's to be commended for doing nonprofit work in the true sense of the word there. He possesses extensive experience both as a litigator and investigator, obviously, having served as a U.S. attorney for the District of Columbia, where he managed more than 400 federal attorneys, and as an independent counsel in the Clinton passport file search matter. If I recall, that was an investigation of Bush administration appointees and officials over the rifling of Mr. Clinton's passport file. In 1997, he was named special counsel by the U.S. House of Representatives to probe the International Brotherhood of Teamsters, and 10 years later, he was retained by the state of New York to investigate then-Governor Eliot Spitzer in the Troopergate matter. He also has extensive experience on Capitol Hill, having served as chief counsel and staff director of the Senate Rules Committee and counsel to the Senate Judiciary, Governmental Affairs, and Select Intelligence Committee. So, again, we can't do better than Joe's expertise in matters of investigations and prosecutions on issues of government corruption. And Paul Orfanedes, right next to me here, he heads Judicial Watch's litigation department and has been with Judicial Watch since its inception. Paul is a distinguished civil litigator who has argued in front of the Supreme Court and in multiple federal appeals courts on behalf of Judicial Watch and its clients. As a director of litigation, he has been a spokesman for Judicial Watch as well, with his legal commentary appearing in major media and print publications. in addition to managing the day-to-day operations of the legal department, which those of you who are lawyers understand is always an interesting thing. Paul is a member of the board of directors of Judicial Watch, so he is as much responsible for the good work we do as folks like me who have the joy of just coming out and talking about all the work Paul's doing. But without Paul's legal expertise, all the success that you read about, we would not have. And so he and his legal team deserve so much of the credit for our good work. Paul graduated from the University of Illinois at Urbana-Champaign in 1986 and received his JD from AU, another AU connection, in 1990. So our guests are going to speak for a bit, and then we'll collaborate a little bit up here and talk amongst ourselves and hopefully get some questions from the audience if we have time. And I'll turn it over first to Mr. Metcalfe.
Well, thank you, Tom. I suppose I should say three things preliminarily. The first is that...
You need to speak more loudly into the microphone, please, Dan.
The first is that I became involved in analyzing this current fact pattern with respect to Secretary Clinton at the request of some journalists who had participated in my academic programs, as has Tom over the years, and I felt an obligation of reciprocity to try to look at things and apply my expertise. The second is that the expertise I have is under the Freedom of Information Act, and secondarily, I know a good deal about the Federal Records Act, but I don't claim to have any expertise whatsoever with respect to criminal law and whether something is a violation of law or illegal in the way that the average person on the street thinks of those words. So when we talk about, or at least when I talk about something being unlawful or in a violation of law, I'm speaking about civil statutes, not criminal statutes for which there could be a criminal sanction. I'll defer to former U.S. Attorney diGenova with respect to that area of things. And the third is that I'm going to base my remarks very heavily, if not exclusively, pun intended, on what has been admitted either by Secretary Clinton publicly at a press conference of March 10th or on her behalf by her counsel and her office in statements that have been issued. And I'm going to suggest that the starting point for looking at all of this would be the first week that she was in office in January of 2009. There are really at least 4 time junctures involved here. One, when she began in 2009 as Secretary of State. 2, when she departed 4 years later in 2013. 3, when she did whatever she did do in 2014 in response to the request that came from the State Department. And then 4 would be currently what she is saying or not saying at her press conference and in any other remarks that are made on her behalf. But at the outset, in January of 2009, she would have, as a new secretary of a cabinet agency, or even as a new agency head more generally, have a briefing with the top administrative people at her agency. Very likely, although I don't know this for certain on personal knowledge, it would have been the Undersecretary for Management at the Department of State and perhaps others, and they would have covered the basic do's and don'ts, the ins and outs of administrative things like federal ethics standards, the requirements of the Federal Records Act, the Freedom of Information Act, the Privacy Act, procurement matters, and things that are like that. And evidently, out of that meeting or series of communications, again, I don't know for sure exactly how that went, it developed, I'll put it that way, that she began to use a personal email account exclusively for all of her official business. And that's something that I'll say right there is atypical, to put it mildly, because the rule under the Federal Records Act and the long-standing practice under the statute and National Archives and Records Administration implementing policies and practices is that it is not absolutely prohibited to ever use a personal email account in the conduct of official business. Yes, if you're a busy Secretary of State and you're responding to crises around the world and in the middle of the night, and you reach for your device or a device, and it's a personal email account or that part of that device, no one's going to come and tell you, stop, you can't address the problems of the world and represent the United States because you're holding the wrong piece of equipment in your hand. And indeed, the National Archives and Records Administration recognizes that. The Federal Records Act, as a practical matter, allows for occasional use of a personal email account under exceptional circumstances. And it does say, beyond that, that when that is done on an exceptional basis, then the official or a staff assistant, as likely would be the case here, has the responsibility to take that communication and transmit it, basically forward it, I think, if in the form of electronic mail, into the State Department's record-keeping system where it would have been located otherwise. However, Secretary of Clinton says quite clearly that she did not begin to use or ever use an official email account, an official State Department email account. She used only the personal email account. And moreover, she never during her tenure took that additional step in any instance, as near as I can tell from the public record, with respect to any of her communications. Then the next aspect of it, distinct but related, is that rather than have her personal email account be handled, for lack of a better word, through an internet service provider such as, say, Google or Yahoo, she instead made use of a private server at her home. So that meant that during the 4 years of her tenure, all of her official communications were outside of the official channels of the State Department, at least at her end as the sender or the sendee, the recipient, and resided purely within her personal control or property or ownership, if that's the correct legal word. And then when she left the department in 2013, it's commonplace for government officials, especially high-level ones, to have special attention paid to them, particular attention paid to them for purposes of records management and archival activities. I had it even when I left as a mere career appointee at the ES5 level, so that a proper delineation is made between what's personal and what's official, and then even within the official category, what's a record or what's a non-record. The whole point being some things will be preserved for posterity through the archives and some will not. And that apparently did not take place. Then what happened in 2014, according to Secretary Clinton and statements that have been made on her behalf, is that she was responding to this special request by the Department of State, and it's a little bit fuzzy perhaps as to exactly what that was all about, but nevertheless she undertook the step of reviewing or analyzing or dealing with, maybe that's a better phrase to use, the emails that were on her personal server. And I'm going to use round numbers here. I think she says there were roughly 60,000 emails, not to be confused with pages. That's a different unit of measurement. We could have an apple and an orange on that. But roughly 60,000 emails, and that of those 60,000, and it might have been 62, roughly 30 or 31 were deemed by her to be personal in nature, and 30 or 31 were deemed to her to be official in nature. And that she then took action with respect to what was on the official side of her delineation, and that amounted to 55,000 pages from roughly 31,000 emails. And she produced that not in electronic form with any metadata that might surround that or ability for it to be searched efficiently for FOIA purposes, for example, but she sent that in paper form to the Department of State, leaving the remainder, which she said at her press conference on March 10th were destroyed or deleted, that's probably the better word that she used, And now the question becomes, well, there's deletion. Were they really completely deleted, or were they completely destroyed? And now she's apparently saying, or it's being said on her behalf to a House committee or a subcommittee, that they were indeed deleted in their entirety. Now, what this amounted to is a flouting, if not an outright violation, of the Federal Records Act requirements, because the Federal Records Act basically says to all agencies and all federal agency employees, hey, you have an obligation to take some steps to preserve things for posterity, okay? And you can't preserve something that doesn't exist to begin with. So the first obligation under the Federal Records Act is to memorialize agency action. Back in the day, memorialization meant creating a piece of paper. And the question was, would something that describes action that took place, would it be reduced to writing so it would become a federal record and possibly would deem to be appropriate to be accessioned and preserved for posterity by the National Archives and Records Administration. Nowadays, of course, with electronic mail, that is itself the very vehicle of agency action. It's not just the memorialization one step removed, it's how, in part, business is done. And what she did by not just using her personal email account in an exceptional case atop the official account, but by not having an official account at all, she acted utterly contrary to the Federal Records Act. And frankly, when I first looked at it, I couldn't tell for sure. I had no personal knowledge, just what I thought made sense, as to whether the State Department had contacted the National Archives folks, the Federal Records Act experts who have government-wide responsibility to oversee the implementation of that law, just as I had it at the Justice Department with respect to the FOIA. And I have since learned that no such contact was made. And in fact, the Archives has sent a formal, I'll use the word request, to the Department of State asking for a report on, for lack of a better phrase, how the hell this all happened. And I don't believe there's been a response to that, but I certainly understand why the Archives has made that quote-unquote request. And now we come to the Freedom of Information Act. And as you may know, it's not unimaginable that there could be requests made to the Department of State under the Freedom of Information Act that could be subject matter requests that by their nature could logically encompass email communications at that high level of the department, or, and that's probably even, this is probably even more to the point for present purposes, requests that specifically ask for her emails, quote unquote, which of course could mean emails from her as the sender or to her as the recipient. And from what I gather, there's been a resounding silence with respect to focus on or attention to that, which is entirely consistent with the fact that if you were the FOIA officer at the State Department and you're trying to respond to such a request in, say, 2009, 10, 11, 12, early 13, you'd go up to the Secretary's office and say, okay, we've got this request, and given its nature, we need to search through Secretary Clinton's emails. The answer would be, well, that won't take very long because there's nothing to search through. We don't have any of them as sender or recipient. The most we have is that if she sent something to somebody elsewhere in the department, that person as recipient would have that. But as a practical matter, that's not a search that's the least bit viable under the Freedom of Information Act. So that's why I have referred to her regime, so to speak, as a prescription for the blatant circumvention of the Freedom of Information Act. And I suppose the other ingredient that I should add on top of that, and I've been very careful in how I phrase this publicly, is that because I worked on so many quote-unquote scandals during the administration, I stopped counting at the number 23. It's more than 2 dozen. And anything that's regarded as a scandal or a controversy has records pertaining to that. So it then becomes a legal issue, a legal/policy issue as to what will happen with respect to those records. Will they be disclosed under the FOIA? Will they be given to Congress? Will they be made public in any other way? Will they even perhaps be subject to subpoena, disclosure, and civil litigation? And having worked on those, and I don't profess to have known every last bit of every last scandal or alleged cover-up, I know enough to know that Secretary Clinton indeed had knowledge of how the Freedom of Information Act works. I worked with folks in the White House, including briefly Cheryl Mills, on related matters, and there's no doubt that she, in my mind at least, based upon my first-hand experience, that she knew full well exactly how it all worked and what she was doing. Now, I'm going to suggest to you, before I talk on too much longer, that a way of looking at this, consistent with what I said about the old-fashioned paper form and the new email form, is to imagine that what the corpus that everyone's focusing on here is in paper form. Just for a moment, imagine that all of these emails, every email that she either sent or received, including attachments, during her tenure, that were not unofficial, that they were piles of pieces of paper. And they were there on this desk right here. And I'm going to suggest that there are at least 8 piles on this desk. The first would be the outgoing emails that she sent to people in the Department of State. And indeed, they would exist at the State Department at the recipient level, so to speak, and be subject to FOIA requests that could never adequately search, given the practicalities of trying to figure out what's what in that respect. The other would be communications from other people of the Department of State. So, in other words, State Department people, piles 1 and 2. The next pile would be people who are federal employees but not at state. And she was a little bit fast and loose on that at her press conference. She had it kind of both ways, but she did acknowledge ultimately that there were other federal employees at other federal agencies, say the Department of Defense, who were at least recipients, if not senders, to her. So that's piles 3 and 4. A sender, recipient, federal, non-state. Then the third set of piles would be recipients or senders from her, people who exchanged correspondence with her, or at least sent something to her, or received something from her, who were other people, not feds, state employees, UN employees, other people, whatever that would mean. When she had a press conference, she placed emphasis on the fact that the vast majority of her recipients, her correspondents, were within the State Department. Well, what about the unvast minority? That's piles 5 and 6 right there. And then I'm going to suggest that 7 or 8 are what she has determined to be personal. Things that she sent, one pile. Things that she received, another pile. And I don't think anyone doubts or quarrels with the fact that there can be some things that are properly in that category. It's unfortunate that it was on a personal email account that also handled official business, but that's entirely legitimate. There's nothing per se suspicious or bad about that. Although one could say that perhaps if 50% of her emails were personal, I know when I was a government official and I would have some personal emails, my wife would say, "You're going to be late again tonight," or, getting on my case about that, or meeting somebody for lunch. That didn't amount to 50% of my emails, about 5% max. So how it got to be 50-50 in her case ought to provide some basis for suspicion right there. And then there's the what I call the mysterious 9th pile. And I'll just leave you with that thought. What would the 9th pile be? Well, reportedly, and here I'm going to be clear in saying what I'm about to tell you, I don't know firsthand. I only know what I've read online, and Lord knows if you can't believe everything you read in the newspapers, that's even true about believing everything that you read online. But it has been reported that her 3 top aides, especially 2 of the 3, one of whom was Cheryl Mills, used either her personal account, and again, I don't know this for fact at all, or their own personal accounts at the State Department where they communicated with one another. And I would suggest that that is a distinct potential pile that ought to be a matter of distinct focus and concern in this case. And I say this, by the way, just by way of concluding statement. I have no axe to grind with respect to Hillary Clinton. I'm a registered Democrat. I'm a self-described liberal. I don't even use the word progressive. I didn't get the memo on when that changed. I'm a liberal, okay, and I've amazed some people by saying if she's the Democratic nominee next year, I'm going to vote for her. I'm not going to vote for the Republican. Apologies to those who were present on that. So I'm just calling it as I see it under the law.
Well, thank you, Dan. It's good that you're retired because I'm sure the Justice Department would be unhappy with your analysis if you were a current employee.
Well, I was somewhat constrained in the past, but you'd be surprised at how candid I was even before I retired.
I have a feeling that's probably true. Thank you. We could do, I don't know if we could do much better in that very careful analysis and very informative and accessible analysis of the issues here. Joe diGenova is, as I said in my introduction, he is a force to be reckoned with on these areas of law and scandal, in the sense of how our institutions in Washington respond to evident violations of law by high-level government officials, and the trouble involved in holding those officials to account. And his experience is, it's hard to match in that area. So we're very lucky to have his presentation. Joe?
Thank you, Tom. One hardly knows where to begin in this matter. The vast array of targets for legitimate inquiry is truly astounding. After 30 years of increasing accountability, transparency, and openness, this incident involving the Secretary of State's email has stopped the clock on accountability. This is the end of the road for all the people out there who care about getting information from their government. As someone who has investigated organized crime, espionage, insider trading, and a host of other things, and conducted congressional investigations of the Teamsters and other things, the basic facts in this case cry out for a formal investigation under the law, not just by Congress, but by the Department of Justice. Let us take a look at what Dan just said. What you have here is a brazen decision to prevent the disclosure of public information to the press, the Congress, the courts, and the American people. It was a deliberate, planned legal strategy from the beginning of her tenure as Secretary of State. And I will ask this question to both Dan and Paul as a rhetorical question, but I don't think it's going to be. What if, in fact, the Department of State from day one was the one that put the server in Chappaqua? And I think they did. And they've known about this before they ever told anybody about it. I believe that will be proved, and I believe it to be the case. But I don't know it yet. Now, investigations and how you do them and the process of it. I'm going to come back to the Department of Justice in a minute. But let's look at how this got started. The investigation of Benghazi, one of the phony scandals, as they've been described by the White House, began with 3 committees in the House: Armed Services, Foreign Affairs, and Intelligence, and then the 4th committee, Oversight, doing a generic investigation. one of the things that you learn as an investigator is you create opportunities for the people you're looking at to make mistakes. You give them a rope. And one of the ways you do that is you issue subpoenas. You don't send letters asking for information. You send subpoenas which have the force of law. And in a minute, I will explain to you why that's important and give you an example from our Teamsters investigation in the 1990s. The reason you send a subpoena is that it creates a legal duty, an obligation to comply, whether it is to a committee, to a court, or to a grand jury, or in a civil case where you are asked to produce evidence in a civil case. And we'll get to that in a minute. The House committees, with the limited exception of the House Oversight Committee, the Armed Services Committee with Buck McKeon, Ed Royce, Foreign Affairs, and Mike Rogers, Intel, conducted 3 of the most incompetent, unsuccessful, and unproductive investigations of a major public policy question in the history of the House of Representatives. It is hard to describe the incompetence that led to the fact, which we now know to be true, that none of them, not a one of them, knew that Hillary Clinton had a private email account from which she conducted all of her business, personal and public. Can you imagine 3 committees and a 4th conducting investigations over a 1.5-year period, and none of them knew that she had that server? You cannot imagine the conversations that are going on in people in law enforcement and outside of law enforcement, and people who used to work on permanent subcommittees in the House and Senate about the incompetence of the Republican investigations. It is staggering. It is also the reason that Mr. Gowdy's committee exists, because the Speaker finally discovered that things were, and I'll be kind, amiss in the digging that was going on. Now, I'm going to tell you something about this server and the attempt to get it and what you do. When you're a prosecutor, you don't have a problem. You have search warrants, you have subpoenas, you can get stuff. When you're in the House, it's not the same. You may be a public grand jury in the sense of any investigating committee, but you can't arrest anybody, although the House does have the authority to arrest someone and put them in the well of the House and hold them in contempt, but that hasn't been done since the 1800s. I may urge them to bring it back. But the powers that exist to investigate generally are pretty powerful. You can go to court and get contempt. You can litigate the issues. But it's not the same as a federal prosecution. Now, you do have options, though. And you can make a problem exist in a bigger way. First of all, you have to issue subpoenas, which those committees didn't do until the very end of their investigations, which was an embarrassment and a mistake. I will tell you what we did in the Teamsters investigations in 1997. We were investigating a corrupt union from top to bottom, run by Ron Carey. It was outrageous what was going on. So the Congress decided to hold hearings. We were retained to be special counsel to the House of Representatives by Speaker Gingrich, and we began an investigation. By the way, the process ended with Carey being thrown out of office and actually a reform president, James Hoffa, being made president of the union by election, and he's been reelected several times. In the course of our investigations, we discovered that the Teamsters had recorded their meetings of their board, and we wanted those tapes. So we subpoenaed them. At the same time we were conducting an investigation, the U.S. Attorney in New York, who was then Mary Jo White, was conducting a criminal investigation of Ron Carey and the Teamsters. The Teamsters General Counsel called Ms. White and said that she had gotten a subpoena. He had gotten a subpoena, excuse me, he, the general counsel of the Teamsters, had gotten a subpoena from the House and for their board tapes. And he wondered if he could deliver those tapes to the U.S. attorney in New York so that we couldn't get them. And she said that would be fine. And they did. They delivered them to New York, all of them, several years of tapes. When we discovered that, we called the U.S. attorney in New York and said, you do realize that those tapes which were handed over to you were under subpoena by the House of Representatives? And they said, yes, well, that doesn't matter. I said, would you please turn over the tapes? And they said no. And I said, all right, we'll be back in touch tomorrow. Went back to my office. We had 2 former FBI agents. We sent them to New York that night with a forthwith subpoena. Now, what is a forthwith subpoena? A forthwith subpoena says, give it to me. It means you turn it over right now. It's not a search warrant, but it's just as good under the law. Because if you don't comply, you better have a good reason. A forthwith subpoena from the House of Representatives. First one ever issued by the House in history. It was delivered to New York. The 2 agents delivered it, called the U.S. attorney and said, will you turn over the tapes? And they said, no. And I said, here are your 2 choices. You can turn over the tapes to the 2 agents who are in the outer limits of your office, or tomorrow morning on the House of Representatives, you will be held in contempt of Congress. You make the decision. You have 5 minutes. We got the tapes. What in the world is the House not doing about this server? The notion that they have to wait. The evidence theoretically has already been destroyed. According to the Secretary and her estimable lawyer, David Kendall, all the emails that she deemed personal, whatever that means, have been permanently deleted. Now, when I began this, I said this was brazen. You bet it is. Just think of what they have admitted publicly. She has admitted that she destroyed, theoretically, government documents under subpoena by the House of Representatives and under subpoena in civil litigation all over the United States. Who says that the deletions were personal? Her staff, and her lawyer based on her representations. That's not good enough. And what's going to happen now is, not only up on the Hill, but in the case of all the Freedom of Information Action cases that are pending, AP, you name it, there are going to have to be affidavits filed under oath by people involved in the process of responding to those subpoenas. These will be DOJ lawyers, Department of State lawyers, people who do records management at the Department of Justice and at the Department of State, Cheryl Mills, and a whole bunch of other people, including Mrs. Clinton. Mrs. Clinton is going to, I will tell you this right, she's going to testify in a federal court. She's going to have to testify in a federal court. And so is Cheryl Mills. And I don't know whether or not any judge sitting in those proceedings will say that Cheryl Mills is, quote unquote, loathsome, like Chief Judge Lamberth did about her not too long ago. But there will be keen interest, if judges are what they used to be, in why no one was ever told that a private email system was the sole basis upon which the Secretary of State conducted business. Let me say this once again. This is the Secretary of State. This is not somebody over at EPA who's working in a bureau on trying to figure out carbon dioxide problems. This is the Secretary of State, an historical figure in terms of the operations of the United States government. And if you go back and you look at Benghazi, I'm going to go there just for a minute because I don't want this to be about Benghazi. When the Accountability Review Board did its quote-unquote investigation of the Benghazi slaughter, they made it their business not to interview Hillary Clinton. Really digging, weren't they? Really digging. No, on their exit, they gave her a report. Mr. Pickering, who was the head of that accountability review board, along with the pathetic Admiral Mullen, said that they didn't think it was necessary to talk to the secretary. I think some federal judges, and clearly Congress, are going to think it's necessary to talk to Mrs. Clinton. Her news conference and the representations of her lawyer, both in writing and in verbally, have now set the stage for a major constitutional confrontation. She has destroyed history. For anybody who cares about government, whether you're a Republican, a Democrat, you're an independent, you're Tea Party, you're a lefto-nutso, the bottom line is simple. She destroyed history. She destroyed history with no supervision, with no accountability, with no transparency. She had no right to do that. And there should be a federal criminal investigation going on right now at the Department of Justice. They don't have to impanel a grand jury. They can start what's called a preliminary inquiry. The evidence on the record at this point makes it very clear that in pending proceedings, she took it upon herself, used her staff, and apparently with the advice of counsel, Cheryl Mills, destroyed evidence. Nobody knows whether what she had was evidence until somebody looks at it. If she's right, and everything that she had that's personal, and I'll bet you the Clinton Foundation is considered personal, has been permanently deleted, she committed a crime. Absolutely, unequivocally committed a crime. And if there isn't a Department of Justice preliminary inquiry, it's a disgrace. Now, I'll just say this. All of the people who were lawyers involved in this, who are going to have to produce affidavits and probably testify in court, they better get themselves some good lawyers. This isn't going to be pretty. Thanks.
Thank you, Joe. Just if I could clarify, there's Mrs. Clinton had said don't worry, there was no classified information on this server in my emails, although yesterday in a court filing, the agency seems to suggest that they would be reviewing her records. A lot of people in the agency had to review her records, and reading between the lines, it was pretty clear they'd have to review their records for classified information, which is only sensible, and which raises other personal criminal issues for Mrs. Clinton as well, the mishandling of classified information. Paul Orfanedes, we've had some really special testimony here from Mr. diGenova and Mr. Metcalfe, and I thought it'd be appropriate to close with you, Paul, and because however important Joe's remarks are in terms of what ought to be done, we generally know what will be done. And it's going to be up to, I think it's fair to say, Judicial Watch to get to the bottom of this, given the Justice Department's conflicts of interest here, Congress's political lack of interest in doing the hard work that Joe is suggesting, and put it charitably, incompetence. And Judicial Watch has proved itself time and time again in being able to get information and the sort of accountability that Joe has been imploring other institutions engage in. It's all through, too often it's all through Judicial Watch's work here. And if you could bring our listeners and our participants here up to date as to where we are, where we're going, and your view as to your view of Mr. Metcalfe's and Mr. diGenova's comments.
Sure. I thought it would be good to talk about some of what Judicial Watch has done in response to the March 3rd revelation about Secretary Clinton's emails. We did what we always do, which is start our FOIA-ing. We have served at least 17 new FOIA requests in the last 4 weeks on the Secretary, on the State Department, including, as Joe will be glad to hear, FOIA requests for records about the server. What did try to find out what the State Department knew about the server, if the State Department in fact paid for the server. I think we have some requests into the Secret Service also about the server, because they are responsible for security at the Clinton's residence in Chappaqua. We've also sent out FOIA requests for records about the Secretary's iPod usage, BlackBerry usage, iPhone usage. We've asked for her separation statement. There's been some news reports that she didn't do one, but we're waiting to see whether or not we get any records on that. If there's a no records response, maybe that might indicate she didn't do it. We've asked for all 55,000 pages of records. We've asked for records about who knew what and when. So we've got about 17 requests outstanding, some more in the hopper. Some of those requests will start coming due in early April, and you can bet that there will be some lawsuits filed in early April. We went back to our database of pending FOIA requests to identify requests that implicated Mrs. Clinton's emails. We filed one new FOIA lawsuit within 2 days of the revelation on March 2nd. We filed hundreds of FOIA lawsuits over the years. So one of the things we had to do was to go back through our databases of pending and even closed FOIA lawsuits to see what this revelation might have, what effect it might have had on either pending or closed cases. We identified at least 9 pending cases that could be impacted and 8 closed cases. Now, with respect to the pending cases, we've asked courts for status conferences. We've reached out to opposing counsel trying to get information on what the State Department is planning to do. One of the things they say they're planning to do is they're going to process all 55,000 records in response and make them available through FOIA.
Pages of records.
Pages of records.
Mm-hmm. Precision is important in this area.
That's right. It's pages of records. But more importantly, we've also asked the court to open some closed cases. The State Department had represented to us in some cases that they had searched the Office of the Secretary and what's called the Executive Secretariat, which is sort of a central office for high-level State Department officials' correspondence and records, including their email. In some of those cases, we were told that those offices were searched. Now, at no point were we told that Secretary Clinton's emails were not captured, or that other high-level State Department employees, such as Ms. Abedin, I believe Philippe Raines, a couple of others, were likely not captured either because they were using this private server. So we've reopened one case. We've moved to reopen one case. We're in negotiations with the State Department about reopening a second case. We have others we're looking at for reopening. Now, interestingly, the Federal Rules of Civil Procedure allow you to reopen a case on if there's new evidence is discovered, if there's surprise. I think surprise is great fun. I'm not quite sure what it means. But also for fraud, misrepresentation, or misconduct. We moved, the first case we moved to reopen, we moved under the provision that authorizes reopening cases for fraud, misconduct, and misrepresentation. The State Department didn't oppose that. Interesting. Now, they claim they didn't realize we were moving under fraud, misrepresentation, but it's plain on the face of our papers. But they seem to be at least open to reopening cases to go back and revisit how these FOIA requests were affected. So that's just sort of a hands-on practical approach to what a group that uses FOIA, how it's been impacted and what it has had to go through in order to try to figure out how its efforts have been affected and what can be done about it. And I'm sure we've spent hundreds, if not thousands of hours of staff hours since March 1st just working on this problem. So it's been a tremendous drain on the organization just to respond to Mrs. Clinton's decision she didn't want to follow the Public Records or follow the Federal Records Act.
Paul, let me ask you, start the questioning with I've always said this it's the catch me if you can presidency, and the shell game that has taken place with these records. And it seems to me the legal position, as best I can tell, there is a legal position, is that, well, Hillary Clinton took these records out of the State Department, or she didn't have them within the State Department. They weren't in the custody control of the State Department. So too bad if we didn't search them. We searched everywhere we thought they would be, and FOIA doesn't cover this, and so we have these now records, and we'll look at those. We may give you some info, but anything before that, we didn't have an obligation to search those records. Ken, I mean, what's your response, given your experience into FOIA, about that extraordinary claim that the head of an agency can evade FOIA simply by removing records from the office?
Well, as Professor Metcalfe referenced, the Federal Records Act applies to these, requires that records be kept that document official government actions. Those records, after they're made, they have to be processed, stored, be available to be used. It's the head of the agency's responsibility to do that, to make sure records are being kept, they're accessible, they can be used, they can be requested. So this notion that the head of the agency, the Secretary Clinton, could concoct this scheme by which she would thwart all of her obligations under the Federal Records Act is not an acceptable response. Now the question is what remedy FOIA allows. There might be some other provisions of law that allow remedies. There could be some criminal provisions. One criminal provision makes it a crime to remove federal records from a federal agency without the permission of the archivist. I think our position is that these records were federal records. They were removed when Mrs. Clinton concocted this scheme to make sure all these records would be on a private server and not on the State Department server. It's a theory we're going to have to test when we get into the stage in court where we're talking about remedying.
It might depend upon what the meaning of removed is.
Certainly, we are dealing with the Clintons.
Yes, because ordinarily one would think removed is it once was here at point A, and then something happened and it was taken to point B. Here it was not created and ever existing at point A. It came to exist only at point B, but it arguably would be functional removal in the same sort of way, I suppose.
I think it existed at point A. It was on the computer, at least until they hit the send button.
Oh, not if it was her private device and it was her personal account. It was not on any State Department computer, I'm afraid.
Those are all great facts we can try to get into in discovery
Okay.
and FOIA requesting. But right, it depends on what the definition of remove is. You know, it's not as clear as Sandy Berger, another Clinton administration official, sticking records in his socks and walking outside of the archives with them. But it is analogous.
The glories of old-fashioned paper copies as opposed to just electronic impulses.
Well, you know, it strikes me as, given my layman's understanding, is that if you're the head of an agency and you set up a system to conduct all government business, that's a government account. And you may pretend you have personal emails on that, but many folks conduct personal business on government accounts. It's not atypical in federal agencies. It's frowned upon. Frankly, it shouldn't happen. But as Mrs. Clinton said, hundreds of people in the agency knew she had this account, and as head of the agency, everyone knew what was going on. So the idea that she, quote, removed this in any substantial way that would have prevented them from being subject to FOIA, I mean, I think it's fair to say our goal is to recover any emails that have been deleted, preserve those that are still out there, and make all of it subject to disclosure as the law requires. And the Justice Department is conflicted on this. We have Justice Department lawyers who I believe knew what their client was doing in the FOIA litigation in terms of keeping this material from us, and they didn't tell the court. And, you know, we ran into this story with the Lois Lerner emails. Again, that was FOIA litigation that I'm convinced by Judicial Watch that forced the disclosure of the lost emails. They wouldn't have told anyone but for, I think, the FOIA process requiring that disclosure. And after we were told those emails were lost, we pushed harder against the Justice Department. And in my view, they continued to mislead the court. But it became, especially since the court wanted more explanations, they fessed up, well, they may be on email servers that are backups. And
let me
there are other emails out there, and Lerner's lost emails became unlost very quickly.
Well, I think that's let me just say this, and I'm embarrassed that I didn't say it at the beginning of my remarks. I am absolutely astounded at what Judicial Watch has accomplished in this arena. It has just been truly wonderful to watch public interest litigation be conducted the way it should be. Excellent lawyers, good arguments, and obviously uncovering some of the most important facts that have been revealed until now. But I want to sort of go on top of what Dan has said. When Mrs. Clinton decided from the beginning of her tenure as a constitutional officer, she is a constitutional officer, that she would procure a server and I now believe with the assistance of the Department of State and with them installing it in her home in Chappaqua, that when she did that, Chappaqua became the Department of State. Those records were, in fact, in the possession of the United States government at that point. I am going to be fascinated by the argument she's going to make that they were not. She moved the Secretary's office from Foggy Bottom to Chappaqua. There is simply no disputing that. She made a decision that her business would be conducted on that server. That was her decision. It wasn't anybody else's decision. When she did that, she transferred federal records into that house and into that server. They may very well argue whatever they want to argue about it, but I think they're going to have a really tough time convincing anybody that those weren't government records from day one in her possession in that place. And when she ordered them to be permanently deleted, and nobody knows what she ordered deleted, nobody knows. Her representations are irrelevant. They mean nothing. They are of such limited evidentiary value, given the scheme that was worked out here to deny access and to deny information, that this is going to be fun to watch.
So that line of reasoning is basically twofold, that when she established or began using her personal email account, that was functionally an official email account, and that when she involved her private email server, that was functionally a government email server as a practical matter. And there is some basis in law not to presume to add to your legal analysis and how you handle your cases. If you look at footnote 10 of the Kissinger decision, and you would be asking the court not only to apply footnote 10, but then to perhaps expand upon it a little bit, extend it a little bit further on this in this extraordinary fact pattern, that would be supportive of what Joe was saying.
Okay, now, so you lawyers raised a
Not to
case
get
that
too-
only
not to get too
people
geeky.
interested in
An
this
A and
area.
B argument.
So the Kissinger decision was essentially a decision based, my understanding is, about how the government could get records from a former official who has arguably government records. And my understanding of the Kissinger decision, and I don't know if this is the footnote you reference, is that it's kind of tough sometimes, but it's not to say, the court, I think, gave itself an out, that a head of an agency taking all the records of a government, all their government activities and keeping them off campus means the government or even a FOIA requester has no recourse under law. Am I right in that?
Well, footnote 10 basically identifies the particular fact that happened to be the case in Kissinger, which is that the FOIA request filed by the Reporters Committee for Freedom of the Press was received by the agency after the quote-unquote removal.
Right.
And that raises the question, which the court did play with a little bit, for lack of a better phrase, as to what the outcome would have been had that not been so. Had the FOIA request had been in place and perfected, so to speak, prior to the removal.
Yeah, let's remember what Kissinger did. When his term was over, he removed his official documents. When his term was over, he removed them, all of them. Mrs. Clinton started her removal of documents at the inception of her secretariat. She began with a purposeful action to conceal and eventually, according to her and her lawyer, delete information which is presumptively public record. It is, in my view, what Kissinger did is normal. He wanted to write his memoirs. He took the papers. He actually he gave bunches of them back, but they existed. The difference is he didn't destroy any. She admits she destroyed more than 50% of everything that was on that server. And if anybody thinks that everything that's official has been turned over, you're living in a dream world.
Well, and just, if our now, I think, I don't know what the facts will show. I suspect when she said the Secret Service is protecting this server, she was not so naive as to think that physically protecting a server from being stolen out of her house was sufficient, and that if that was an accidental truth, that the Secret Service was maintaining this server, and if it indeed was a State Department server, that whenever she deleted those records, who in the agency knew that they allowed Mrs. Clinton to delete those records from a state agency server? Who in the White House knew about this issue? Why did they allow her to delete those records? The implications here are really staggering, and you can see why you have this sensitivity. And initially, smart Democrats on the Hill, not really knowing what all the facts were, they've been around the block. People like Senator Feinstein and I think even Dick Durbin came out and said, just tell us what's happened. And Mrs. Clinton didn't read between the lines and decide to be truthful to those requests. But I think folks on both political parties understand there's a big issue here. We've gone over, but I want to leave some time for some questions, at least before we go. Mark Tapscott, Washington Examiner up front here. I think we have a microphone so folks can hear. So we're going to take one of the microphones from here, and if Dan and Joe could share. Yeah, we're fine.
I want to go back to the meeting, the briefing that Clinton got, presumably, at the outset. If I'm Patrick Kennedy in that meeting, the Undersecretary for Administration, and I say to her, you use the government email, and she says, no, I'm going to use my own. What are my legal responsibilities and obligations at that point to attempt to ensure, or at least to memorialize, what happened in that meeting?
Well, this is a civil matter, so I'll take it. And
for the moment.
For the moment, right? And I can only speak in comparison to what I know happened at the Justice Department every time there was a new Attorney General. Routinely, this sort of administrative meeting would be held in one form or fashion sooner rather than later. And I would dare say the top administrative career official of an agency has the responsibility, A, to make it clear what the law and policy requires, to be more refined and say, well, just because you're not flatly prohibited from ever using a personal account doesn't mean you can always use a personal account. There's a lot of daylight in between the two. And assuming the worst for this purposes of this question, that he learned in that meeting, if he in fact was there, and we're speculating, okay, that she did not intend to do that, then I believe he would have had an obligation at a minimum to contact the people at the National Archives and Records Administration who hold the statutory responsibility for overseeing and properly implementing the Federal Records Act, up to and including the Archivist of the United States, with the idea that the archivist, having learned of this development, would then call the secretary and say, Ms. Secretary Clinton, you just can't do that. It's not consistent with and indeed flouts the Federal Records Act. If, on the other hand, he didn't learn that, or no one learned that, it was just stated to be what should be done, and then she went away and did what she did on her own, then the question would be, well, when was that learned, and wouldn't that same obligation arise?
Which is the next part of my question. At some point, it became obvious to a bunch of people there that she was using a non-government email. Is there an obligation at that point?
Well, I'm going to cut them, those people, those anonymous people as recipients, I'm going to cut them a bit of a break, so to speak, because they don't know, as mere program people, they're not administrative people, they don't know what took place in the meeting. So maybe they can assume, they're not supposed to be experts in the Federal Records Act, maybe they can assume that it's okay. And I don't think they have a direct obligation to do otherwise and to take any action. It really is on the administrative people who have the delegated authority from the archivist to make sure that the Federal Records Act is followed at that agency. So if the records management people learned thereafter, yes, they indeed would have that. But if the Assistant Secretary of State for Far Eastern Affairs learned that, that would be a different matter entirely.
Let me add to that, if I might. Your question is actually at the heart of the matter. Mr. Kennedy is a very important person in this entire scenario of records production and of policy issues related to record production. Mr. Kennedy is one tough cookie. He ruins people's career for a living. That's what he does. He is an apparatchik in every sense of the word. When and if he was the person who briefed Mrs. Clinton on what her duties were, I can assure you that it would have been a groveling presentation. The bottom line here is that whatever the duties were of a whole bunch of people at the State Department, they didn't perform them. I agree with Dan. You can't put the onus on this on the people inside the State Department getting emails from Hillary. They don't know. That, as far as they're concerned, that's one email. They don't know where she is or what she's doing. At a certain point, the information management people at the department know that she's not using an official email account. They know that for a fact because she doesn't have one. It doesn't take a lot for somebody to start asking questions like, excuse me, Madam Secretary, but just how are you communicating with people in the department, and where are those records? This is so staggering in the brazenness of evasion of legal duty by everybody at the State Department, and especially the Secretary, that it is simply staggering. It's unbelievable. And with a straight face, she stands up at the UN and talks about yoga lessons and laughs about it before a media group recently and makes a joke about her emails. And of course, the media in the audience laughs uproariously at this wonderful event. What she has done has undermined people's confidence in the ability to get valuable public records. Her records were valuable. Whatever you may think of her, she was the Secretary of State. That's a pretty big job. And she took it upon herself to change history. She does not have the right or the authority to change history, and she did.
And Mr. Kennedy is still at the agency, still is the responsible official for record searches and managing records and that separation agreement. The idea that there is a distinction between Mrs. Clinton personally, she is the agency for legal purposes here, and there's no daylight as far as we're concerned between this current State Department and Mrs. Clinton. This is State Department responsibility, and the folks there is liable, potentially, as Joe points out, as others.
Can I just make one minor little point? Because there are a lot of facts here that are undisputed. They come from Secretary Clinton herself or from people speaking on her behalf. But I don't know for a fact that Patrick Kennedy was in such a meeting. For all I know for sure, he might have been having surgery that month, and it could have been a deputy or two deputies or something like that. We really do not know for sure. But the responsibility is in his office for somebody to take the lead on such an important matter.
Well, there have been several court filings since this scandal broke, and I think we have all the lawyers here from Judicial Watch who have been involved. And I think I'm correct in saying the State Department is yet to disclose to us when they became aware of these accounts of Mrs. Clinton.
Now, also, I agree completely with Dan said about not knowing who it was. But here's a better question. How about if she didn't get a briefing at all? And I'm going to tell you something. She didn't. She didn't get a briefing because they treated her exactly the way Thomas Pickering of the Accountability Review Board treated her. You don't touch her. You don't get her angry at you and Cheryl Mills angry at you by asking tough questions. You treat her like a queen. She gets a pass. She doesn't have to do anything. I would be amazed if she got the traditional briefing that other secretaries of state have gotten when they came into office.
Right.
They probably would have given it to Mrs. Mills.
I'm going to agree with you with your speculation in one respect. I happen to know firsthand that there was an Attorney General of the Justice Department who was treated not unlike that. So that makes it all the more plausible that it might have worked there, and that was Alberto Gonzalez. Right. And when I deposed him for 6.5 hours down in Lubbock, Texas, on his understanding of the Federal Records Act and the Privacy Act, that became painfully clear.
We have time for one more question. Yes, sir. In the center here.
I seem to remember the department has a category similar to for fish use only. I think it's is it LU, limited official use, something like that. It's above unclassified but below classified, and I'm wondering that so many of the daily emails with the department, if they're not classified, they would probably be this LOU category. It's like a fish use only, and I'm wondering, does that make some difference on the security or lack thereof of this server up in New York?
Well, having some familiarity with what's called sensitive but unclassified information, because I wrote the damn White House memo in March of '09 that started everything off on that, I do know that the State Department uses at least two such designations in what's known as the pseudo-secrecy realm. One is called no form, and the other is no dis, NOFORM, NODIS, and it might use for official use only or something like that as well. What that has to do with is labels that are attached to records, most easily in the paper realm, that call for special safeguarding and special handling. And your point, I think, is a good one. I touched on it in the Politico magazine article that I wrote a couple of weeks ago, that even if nothing on her server was classified, which is what she has said, and for all any of us in this room know, is entirely possible. It was not reviewed for classification, which is another matter, but even if that's so, it's very, very hard to believe there wasn't at least some SBU, sensitive but unclassified information of that level, that was there, for which a special handling requirement would have been warranted under how the State Department ordinarily operates.
Well, if we take Mrs. Clinton at her own word, that this server was private, it didn't have the security requirements that State Department servers would. So just imagine the types of information that would be left on the equivalent of an internet park bench by Mrs. Clinton as a result. You have classified information potentially. You have personnel information potentially. Personnel issues are presumably part of her handling, a part of her day-to-day duties. So someone's personnel files are on the Internet Park Bench. Someone's Privacy Act protected files are on the Internet Park Bench. Sensitive information from abroad are on that Internet Park Bench. Maybe sources that need to be protected are on that Internet Park Bench. Maybe the private information of corporations doing business with the State Department are on that Internet Park Bench. Maybe security concerns about Benghazi and or security issues related to other diplomatic facilities are on that Internet Park Bench. You can imagine those who would be interested on that. So you have all this information that as the agency head, she's supposed to protect. And in protecting that information, she's protecting other people in the agency and citizens outside the agency and other government officials outside the agency, both here and abroad. So there are a lot of people who've been harmed by this misconduct potentially, if this was not secured as it was supposed to be. And so this is why you get the reaction that you're getting from diGenova. And you know, as Paul pointed out, we've been gamed as well. But we have access to the courts. We've got great lawyers. But there are a lot of people who know they've been gamed out there who don't have access to the courts and probably will never get justice by this. And I'll just close on this note. You know, as I said, I think this whole case was broken open because of our insistence on getting information from Mrs. Clinton and her office about her involvement in the Benghazi scandal. And we talk about the Benghazi scandal as if it's just a political issue, but it's about whether or not 4 Americans died unnecessarily as a result of decisions made by Mrs. Clinton and the Obama administration, both in terms of refusing to provide them security that was requested, security that was pulled out eventually, and then once the attack began, not going to their aid. So there are people who have died that need to be vindicated, and that's why we were investigating this. And the lack of and the failure to go protect those people, the failure to provide them security, and then lying about what happened for political purposes has really decimated the morale of the military and other civilian personnel deployed overseas. Because the compact has been that if things hit the fan, the government will be there to save us. And we were investigating why that compact was torn asunder by this administration. And this is what we uncovered. And in the light, and even after all of that even after all of that became public, and the controversy, the select committee asking questions, this person, Hillary Clinton, deleted all of her email by the admission of her own lawyer. Really incredible. So this is not your typical political scandal. There were no dead bodies in Watergate.
Tom, could I just touch on one point with respect to the word delete? And that's a relatively recent development as of Friday of last week, when I believe the phrase used by the Gowdy committee or subcommittee is that he heard from David Kendall that it was wiped clean. I'm told by my technical experts, which are largely my computer security daughter who works for Google out in California, that traditionally, or in the olden days, to wipe something clean, you would degauss it. That would be an electromagnetic fix. Or you would even mechanically take a hammer to the darn hard drive. But that nowadays, there is software, especially something called Kill Disk, aptly named perhaps, whereby it's approved by NSA that if you run it 3 times over, it will sufficiently overwrite what's there. And I'm told that that's everything, not just the text of the email itself, but the metadata surrounding it in the server logs. And if she did that, if she took that extraordinary step, then perhaps it would all be gone. But then the very taking of that step might be a basis for inferring intent that would be more in Joe's area as to what she was taking great measures to do.
I hope you didn't give her any good ideas now, Dan, with that.
Let me just say one thing, just
go ahead.
factually about Benghazi. It's really important for people to realize this, and it's why Patrick Kennedy is such an important person. Just remember who he was. All of those African bombings during the 90s, he was the guy in charge of security. And he got promoted after those disasters. During his tenure to this day, during Benghazi, Ambassador Stevens wanted security increased. He had 38 people. He wanted more. The country was a disaster. Do you know what Kennedy did? He reduced it from 38 to 9. There were 9 security people in country. That's it.
No. Well, as I said, we were just obtained these records about the Mrs. Clinton's top staff, Cheryl Mills, her executive assistant, which is an ambassador rank in the State Department. So it's not what we traditionally understand an executive assistant to be. He's given he had the rank of ambassador. What did they know about these emails? And there's no doubt Mrs. Clinton was her top people were being updated about the truth of what was going on in Benghazi as the attack occurred, and yet they put out that false information. So I think there's what is there to hide? There's a great incentive not only on Benghazi, but on her abusing her office to raise money for her political operation at the foundation, and basically to launder money into for her personal benefit, is something that would be of significance. And like I said, this idea of personal versus official records, I think, is one that you have to take their explanations with a grain of salt. And I'm pleased to say that Paul Orfanedes and our litigation team here at Judicial Watch are going to be raising these issues with the court and various courts. And we're already before 2 federal court judges. We'll shortly be before a 3rd, and we're prepped to go to other court judges. There's got to be accountability here, and I would encourage those of you listening to ask their members of Congress, why aren't they doing what Judicial Watch is doing? Why aren't they hiring Judicial Watch or Joe diGenova again to do another special prosecution of this scandal? And why is the Justice Department continuing to do nothing and arguably impede further information gathering about this scandal and acting as a co-counsel, it looks to us, for Mrs. Clinton personally in the litigation we're currently involved in? It's getting worse, not better for Mrs. Clinton, and the media will try to move on and pretend it's all about politics as she announces her run for the presidency. But running for the presidency shouldn't make you be immune from any serious accountability under law. And that seems to be the way it seems to work in Washington, and we're going to change that through our litigation, that running for high office doesn't place you above the law. And Mrs. Clinton should learn that, and certainly the agencies at the State Department shouldn't allow, at both at State and Justice and within the White House itself, need to start paying attention to their obligations to the public interest as opposed to the political future of the Democratic Party, which is where I fear it's going. But I just hope there's an honest man in the administration or an honest woman who says, we're done, and we're just going to let it all hang out, and there's no harm in coming forward and being forthright to the courts and to investigators, but to continue the cover-up, which is ongoing in my view, really shows you what we're up against. And it's going to be, if Congress gets its act together, if the Justice Department finally gets its act together, and hopefully a federal court judge, just one, being upset enough to bring some of these folks before him or her and ask them questions or allow us to ask questions, really could work wonders. So we're prepared to work hard. We appreciate the work here of Paul, obviously, at Judicial Watch, and Mr. Metcalfe, who has tried to provide an honest analysis of what the legal issues are and what the facts are based on his experience, which is
I care only
significant.
about good government and rule of law. That's where I come from.
And he's available at the Washington School of Law's website and his collaboration on government secrecy. And Joe diGenova has been doing yeoman's work in this area as well. And I hope more people pay attention to his analysis. And Congress needs to really refigure and restructure their investigations and how they go about in conducting oversight. Because although we're happy to do it, it really is outrageous that we're doing the job of both Congress and the media, just one little old Judicial Watch taking on the $4 trillion federal government. And my gosh, we need the help, and Congress needs to start doing its job. So thank you, everyone, for participating, and you can learn more about this and track the scandal at judicialwatch.org. And you can Google Joe and Mr. Metcalfe at AU. And Joe, what's your website, if you have one?
Just www.digenovafencing.com.
So you can Google him and find out all about their great work. And if you want to throw out your website, Dan, this is your opportunity.
Well, the easiest way is to just go onto Google, my family's favorite website, because my daughter works there, and put in my last name, which is Metcalfe with an E on the end, and one more word, and that word is secrecy. Well, and that'll get you to my faculty page as well as other things.
Well, thank you very much. And again, thank you for your participation in the educational panel today.